Today, my groupmates and I will be talking about the topic of trespass to person.
Today we'll be talking about trespass. Trespass is an area of criminal law or tort law which can be broadly divided into three groups: trespass to person, trespass to chattels, and trespass to land. However, for the purpose of this video presentation, we'll be focusing on the tort of trespass to person. A person is said to have committed trespass to person when he is found to be guilty of direct coupled with forcible bodily interference without any consent. A suit is actionable even if no bodily injury has been sustained. As long as a legal right has been violated, such action by the way of a lawsuit can be taken. As decided by the case of Litang and Cooper, intent is required to sustain a trespass to the person's cause of action. In the absence of intent, negligence is the appropriate tort. Summarizes the shift in law, and I quote, "Under the old law, whenever one man injured another by the direct and immediate application of force, the plaintiff could sue the defendant in trespass to the person without alleging negligence. Whereas if the injury was only consequential, he had to sue in case. You will remember the illustration given by Mr. Justice Fortescue in Reynolds v. Clark in 1726. If a man throws a log into the highway and in that act it hits me, I may maintain trespass because it is an immediate wrong. But if as it lies there I tumble over it and receive an injury, I must bring an action upon the case because it is only prejudicial in consequence. Nowadays, if a man carelessly throws a piece of wood from a house into a roadway, then whether it hits the plaintiff or he tumbles over it the next moment, the action would not be trespass of case, but simply negligence." There are three parts to trespass to person: assault, battery, and false imprisonment. Assault can be defined as any act of such a nature as to excite an apprehension of battery. Battery can be defined as any intentional and unpermitted contact with the plaintiff's person or anything attached to it and practically identified with it. False imprisonment can be defined as the unlawful obstruction or deprivation of freedom from restraint of movement. Essentially, the main ingredients of trespass to person is: an act does not constitute trespass to person unless it is done with intention. Thus, intention is the chief criteria for trespass to person. If there is an intention behind committing a trespass, then it is actionable per se, and the plaintiff need not prove any specific or particular damage. In negligent commission of trespass to person, plaintiff needs to prove the injuries to complaint. We will now move on to battery.
Firstly, let's look at battery. According to Wilford and Jolowitz, battery is the intentional and direct application of force to another person. In Fagan and Metropolitan Police Commissioner, battery is defined as the actual intended use of unlawful force to another person without his consent. Thus, battery is basically an intentional act of the defendant that directly caused physical contact towards the claimant without the claimant's consent. To consider an act as battery, we should firstly look at whether the act was done with intentions or negligence. In Litang and Cooper, the defendant who negligently drove his car over the claimant's leg and injured her was held not liable. Lord Denning stated that when the injury is not inflicted intentionally but negligently, the only cause of action is negligence and not trespass. Next, in Fowler and Laney, the plaintiff brought claim under trespass to person and accepted simply that the defendant should meet. Without setting out the particulars of intention or negligence, the defendant argued that the statement of claim disclosed no cause of action. Lord Diplock agreed with the defendants and proposed that the burden to show the shooting was either intentional or negligent was on the burden of. Lord Diplock agreed with the defendant and proposed that the burden to show the shooting was either intentional or negligent was on the plaintiff. This shows that the plaintiff must assert intent or negligence in the claim as it is an essential element of claim. Normally, the English jurisdiction is followed in Malaysian context. In August 2018, the plaintiff was arrested by a group of special branch officers without a warrant of arrest and never told the reason of arrest. The plaintiff was physically abused in the detention. The court held that the act of detaining someone and applying physical force to extract information clearly amounts to torture. When the act is committed The claimant was a soldier in Northern Ireland who intended to fire a revolver, but he missed and hit the claimant, was found liable. This is because the court held that the claimant's intention was to hit someone and had intentionally applied the force. The fact that the actual person hit was not the intended target is irrelevant. The intention to apply force need not to be present at the beginning of the act. In Fogarty Metropolitan Police Commissioner, the defendant accidentally drove over a police officer's foot, but once he knew, he delayed in removing his car and ignored the constable pleas. The defendant was held liable as the court held that the intention could be formed later. Furthermore, intention and the direct act have a wider interpretation in Hastings and Chief Constable Derbyshire. In this case, the defendant punched the woman who was holding her baby twice. As a direct result of the punches, the baby fell from her arms and hit his head on the floor. As the defendant was aware that she was holding the child and he would foresee the risk of the child being injured because of the force he used of the woman, he was convicted of the offense of battery against the child. The court held that the movement of the lady when she lost hold of the child was directly the result of the defendant's action in punching her. Thus, the defendant was held liable in trespass. The defendant then appealed on the ground that he did not directly apply force on the child. However, his argument was rejected. Therefore, battery did not require the direct infliction of violence. Next, there must be physical contact between the parties. This violation of personal space is the essence of the tort. Lord Gough in Collins and Wilcox stated that law cannot draw the lines between different degrees of violence and therefore totally prohibits the first and lowest stage of it. There is an exception on general acceptable conduct with implied consent such as a tap on the shoulder. According to R and Chief Constable of Devon and Cornwall, an unwanted kiss would amount to battery. Lord Gough in F and West Berkshire suggested that battery not only protect a person from physical injury but any form of physical molestation. Thus, as what Lord Gough stated, we can conclude that the nature of contact as any contact that is not impliedly consented to as generally acceptable in the ordinary conduct of daily life. Moreover, in Wilson and Pringle, Lord Groom Johnson suggested that contact need to be hostile. In this case, both defendant and claimant were schoolboys. The defendant jumped onto the claimant to pull his bag off his shoulder. The claimant then fell and broke his leg. The defendant argued that the incident was just a kind of playing and it was normal among boys. The Court of Appeal held that whether it amounted to a battery depended on whether there was an element of hostility. However, Lord Gough doubted this statement and suggested that any touching of the body without lawful excuse capable of amounting to a battery.
Going to talk about defenses to trespass to person of battery. There are three main defenses available, which is consent, necessity, and also self-defense. I would like to begin my part with a brief introduction of consent. Consent can be used as a defense to battery when a claimant agrees or gives permission to what the defendant does. Hence, there is no liability for trespass. Consent may be given expressly by words or be implied from conduct. For instance, consent is deemed to be given expressly when a patient signs a consent form agreeing for an operation. When implied consent can be shown through behavior such as implied consent for hairdresser to touch you while cutting your hair. As we can see in Nash and Shin, which the hairdressing salon used the wrong kind of chemical to the plaintiff's hair without getting consent from the plaintiff, and therefore the plaintiff developed some skin complications due to an adverse reaction to the tongue rinse used. The court held that the consent given by the plaintiff did not include the tongue rinse and its consequence, so the battery was established. Next, consent can be applied in sporting events. Those who take part in sports also consent to a reasonable degree of physical contact during the course of play. For example, within the accepted rules, even to the risk of being unintentionally injured, as we can see in Sim and Leigh Rugby Football Club. Plaintiff sustained a broken leg from a lawful tackle in rugby game, but because of the unintentionally injured, so there was no battery. However, it can be no consent to deliberate acts of violence. In other words, trespass that occurs as a result of behavior outside the rules is amounted to battery. In addition, consent can be raised in medical cases. There are two categories divided by still. The first category is cases where the consent refused. In the case of Riti, which the patient involved refused to be amputated and the consequence was he would die, it was held that where patient is an adult of sound mind and capable of exercising his or her own judgment and consent is refused, the doctor must follow with the view and the decision of the patient. On other side, a Malaysian case, Asia BTE Kamsa and Dr. Rajinder Singh and Oz, the court held that consent will negate any purported unacceptable conduct of defendant. Second category is cases where consent or refusal cannot be obtained and have to look at best interest of consent. In Airedale and HS Trust and Blend, patient in vegetative state for 3 years was judged no hope of recovery and lawful to stop artificial feeding, which was maintaining his life. The House of Lords held that the best interest of the patient required the treatment to prolong his life should be discontinued so the medical team was not liable. Moreover, there is also defense of necessity for battery. This defense is used as an argument for treating a patient who is unable to give a clear consent. As we can see in UF, F was a 36-year-old woman and suffered from serious mental disability. She then had 2 children suffer from verbal and mental capacity each and again. She developed a sexual relationship with fellow patients. She was concerned for not being able to cope with pregnancy and unable to raise a child herself. Hence, it was lawful for her to undergo sterilization, but she unable to give a valid consent since she did not appreciate the implications of the operation. The issue is whether it is lawful for doctors to operate without her consent. The answer is yes. This is because, as ruled by Lord Gough, the basic requirements applicable in these cases of necessity were not only must there be a necessity to act when it is not practicable to communicate with the assisted person, but also the action in all circumstances acting in the best interest of the assisted person. Besides, the third defense is self-defense. The defense is available provided that he had a reasonable apprehension of immediate harm and that his actions were proportionate to the threat. In Land and Holloway, this case was about dispute between neighbors. Claimant had been drinking and got into an argument with the defendant's wife. During that moment, he called her a monkey-faced child. Hearing this, the defendant came out and said he wanted to see the claimant alone. Believing he was to be hit, the claimant smacked the defendant on the shoulder. The defendant responded by punching the claimant in the eyes, causing a wound which needed 19 stitches. The court held that the defendant had reasonable grounds to believe he needed to defend himself, but said that his blow was out of proportion to the danger, so he was not covered by self-defense.
We'll now be moving on to the topic of assault.
Okay, so basically, assault was defined by Winfield as an act of the defendant which causes the claimant a reasonable apprehension of the infliction of battery on him by the defendant. So it was also defined in Fagan and Metropolitan Police Commissioner as any act which intentionally causes another person to apprehend immediate and unlawful personal violence. So basically, there are several key elements in assault which needed to be fulfilled if one wishes to bring a cause of action against another under assault. So firstly, the defendant must act. Obvious examples of actions that could amount to assault would be an attempt to beat another but without touching him, strikes at someone but misses him, and also when you point a gun at someone. So in the past, it was thought that there had to be some physical movement, but it now appears that threatening word itself may be sufficient. So the question has not been tested in any tort case, but the idea of criminal offense of assault was being brought up in this case to fit in the lacuna of tort. In R.V. Mietenbal, it was originally held that no words or singing are equivalent to assault. But in Tugolele and Savage, however, it was held that words amount to assault if it results in apprehension of immediate physical harm. So the question regarding words in assault is whether the maker of silent phone calls could be convicted of assault. The case of R.V. Allen concerned a defendant who made silent telephone calls to the claimant, which was liable of assault because his action made the victim fear that he was about to appear at the door and commit violence against him. So according to Lord Steyn, the proposition that words can never amount to assault is realistic because a thing said is also a thing done. So there's no reason why a man who traps a woman in the dark alley saying, "Come with me or I will stab you," can escape from liability of assault. So depending on the circumstances, liability should be imposed accordingly. Lord Hope in this case mentioned as well, rejecting the proposition that words can never amount to assault. In his point of view, as long as the silent phone call leads to a result where the victim is free of uncertainty of defendant's action or apprehension of immediate unlawful violence, not just a repetition of telephone calls. The second element of assault is the mental element or the intention. Particularly, intention is shown when the means of carrying out physical harm is available and the victim actually apprehends the immediate physical harm. This was illustrated in Beverley and Savage as the defendant put forward his sentence, "If it were not assist time, I would not take such language from you." So basically, assist were traveling courts. So what the defendant was trying to say was that with the judges in town, he would not take the risk of using his swords against the claimant. So this clearly means that despite the threatening gesture, the claimant was in no immediate danger, therefore no assault was committed. Thirdly, in imposing liability of assault, the court looked into whether the claimant apprehends unlawful immediate physical harm. So in other words, to sue successfully in assault, threatening act or words must be of a kind that could give the claimant an apprehension or a reasonable expectation that the defendant is going to use violence against them at that time. By the way, there is one important point to take note, which is the claimant does not have to prove he or she is afraid of the violence. Merely expectation of happening of the violence itself is enough. Moreover, most importantly, there may be assaults where defendants conduct give the claimant good reason to expect immediate physical violence, but in fact, the danger does not exist. For example, if you point a gun at someone and you know that it is unloaded, but they do not, you may be liable because he or she apprehends vicinity of danger. So this idea was illustrated in the case of R.V. St. George. However, this would not be the case if the claimant knew that the gun was not loaded. So up to this point, the controversial thing arises as to whether the defendant must intend his act to cause immediate apprehension of harm in the claimant, and also whether the defendant must realize that his action causes claimant to suffer vicinity of harm. It has been suggested in Vice and Ministry of Defense that this should be the case. However, the defendant may simply try to defeat a claim for assault by arguing that his personal subjective intention was not to cause the claimant any apprehension. Although viewing his conduct objectively by a reasonable person, this is exactly what he did. So fortunately, a judge or jury is not prepared to recognize the so-called innocence in this circumstance.
In order to claim an assault, the capability to carry out the physical harm must be positive or present. For example, assault is committed when someone raises his or her fist at another who is standing right in front, but not when doing it from a train as it speeds past another who is standing by the track. When there is no reason to believe immediate physical force is capable of being used against claimant, no assault is committed. The case of Thomas and National Union of Mine Workers was about the 1984 miners' strike, and the claimant was a miner who had refused to join his colleague in the strike. He was brought to mine every day by a special bus so that he did not need to encounter those strikers. So as the bus drove through, the strikers made violent gestures at those inside. The court held that those actions could not amount to assault as the claimant was safe inside the bus and police were monitoring those strikers. Also, When threatening act is so close to successful implementation, but for some reasons did not succeed in carrying it out, assault is committed. In Stephen and Meyer, the defendant sought to punch the claimant but was physically unsuccessful because stopped and intervened by the third party. However, assault committed as claimant was put in fear and immediate physical harm, and according to witness in the case, but for the intervention of the third party, defendant would have carried out the threatening act. Generally, principles of assault in English jurisdiction are followed in Malaysian context. The application can be seen in the case of Abu Malik bin Husin and Burhan bin Haji Daud. In this case, the plaintiff was arrested without a warrant by a group of special branch officials and was vaguely told that he was being arrested under the Internal Security Act 1960. He was then handcuffed and slapped thrice by the first defendant when he failed to report location of his car. On the way being brought to a lonely place, he was blindfolded and verbally abused by the defendant. After all, the High Court held assault has been committed against the plaintiff. We can see from this case that the High Court took into account all core elements before imposed liability of assault on the defendants. Firstly, there was an act in verbal or words form which was used against the plaintiff. Secondly, intention of treating plaintiff with abusive words was evident as the action was carried out by not only one, by several defendants. Thirdly, the verbal abuse clearly resulted in plaintiff apprehended unlawful immediate physical harm as he was crowded by several people and being abused in a lonely place. Furthermore, actual unlawful physical abuse was followed by verbal abuse. Lastly, capability to carry out the threatening act in this case is a non-controversial point where, in fact, the defendants did apply the act on body of plaintiff to his person. Apart from that, application of assault principle in English context was shown in the case of Marni binti Anim and Shalini Shamugam and others. In this case, the plaintiff, Marni Anim, was employed by Mr. Vijaya and Madam Shalini as their housing maid or domestic helper. Along the course of her employment, Marni has suffered moral degradation, verbal and physical abuse by Mr. Vijaya's wife, Madam Shalini. When the plaintiffs ran away from their residence, lodged a police report and went through a medical examination, this case was brought before the session court in Kuching. The defendants jointly denied their alleged abuses and averred that she was treated like their own daughter. Fortunately, the court did not ready to let the defendants escape from their liabilities and make them liable in assault. As similar to previous case, the court took into consideration 4 core elements in establishing assaults. All the elements, namely presence of an act, verbal in this case, and intention of carrying out the threatening act, reasonable apprehensions of unlawful immediate physical harm, and lastly, the capability of carrying out the threatening act was positive and present in this case. This is because several and multiple actual physical abuse was proved to be real from the physical examination. So, as a conclusion, when abusive words are used, followed by actual abusive physical harm, assault is said to be established. We then move on to consider the differences between assault and battery. Firstly, regarding matter of consent, the issue of consent does not arise in assault, but in order to successfully sue in battery, the defendant's act must be done without plaintiff consent. Secondly, in assault, the claimant experiences reasonable apprehensions of an immediate infliction of force upon his person, meaning no physical contact with the claimant is needed. However, in battery, there must be physical and action contact, always direct transmission of force between the defendant and the claimant. Last but not least, assault protects one from the threat of any physical violence as well as to maintain a person's mental well-being. Nevertheless, the thought of battery protects one from physical contact, violence or otherwise, as long as it is unnecessary and unauthorized contact.
Last but not least, we'll be talking about false imprisonment.
Today, I'll be talking about false imprisonment. There are a few definitions being stated around way back then. For one is Winfield. It states that infliction of bodily restraint which is not expressly or impliedly authorized by the law, and also by Steele, which states that unlawful and total physical restraint of the liberty of the claimant. That also is one of the definitions being stated. So there are a few elements that need to be satisfied in order to amount to false imprisonment that could be brought by a claimant. So first is intention, which is so-called mental element as well. Second one is there must be total restraint, no partial restraint is allowed, and unlawful imprisonment. So for the first element, intention, is being stated that in the case of R and Governor of Brock Hill Prison, where the defendant intend to restrain the claimant full and total. So in the end, House of Lords held that the prison governor was liable in damages for false imprisonment, as the detention for those additional days were unlawful, even though the governor could not have been aware of the new guidelines at that time, yet it was intention. However, failure to act will not amount to false imprisonment as intention it is, as shown in the case of Iqbal and Prison Officers Association. In this case, a prisoner brought up a case against prison guards who had gone on strike and caused him to be locked up in his cell all day. He claimed that he was falsely imprisoned, as his usual practice of being allowed at a common area for 5 hours a day was taken away from him. Courts held that there is no liability in tort for failure to act. Another case that assuring such element must be proved in order to bring up a case of false imprisonment is being shown in the case of Sayers and Harlow Urban District Council. It stated that the claimant was trapped in a toilet cubicle due to a defective lock and injured herself while trying to escape. She sued the defendant for false imprisonment, but it was held that there was no intention caused by the defendant and deliberate act which caused her to be trapped. However, defendant is liable for negligence of not repairing the defective lock. And a much more recent case is being shown through Best and R, 2015. The offender and several co-offenders had falsely imprisoned 3 persons as a consequence of money being paid by the offenders in a drug trafficking transaction and ensuing failure of the suppliers to deliver the promised drugs. I will move on to the second element, which is called total restraint. The main point is that total deprivation of freedom of movement must be shown and must be fulfilled. Partial restraint does not amount to a false imprisonment, and in order to be called total restraint, freedom of movement must be entirely impeded. Through the case of Burt and Jones, we can see that when the alternative road was presented, defendant was held not liable for false imprisonment. Thirdly, the element that needs to be fulfilled is that unlawful imprisonment. The fact that claimant need not to be aware of false imprisonment to hold defendant liable, as we can see through the case of Mearing and Graham White Aviation Co. Limited. Claimant was suspected for stealing plane. He was noted of employer suspicion. Claimant was asked to enter the company's office with 2 police officers' supervision. Claimant was not held aware of presence of officers outside the office while he was being questioned, yet claimant sued for false imprisonment. But the Court of Appeal held that the claimant was no longer free when police were involved and claimant's awareness of such was irrelevant. False imprisonment could also be committed even when the claimant was asleep, drunk, or even unconscious. Such approach was later confirmed by House of Lords through the case of Murray and Ministry of Defence. Through the case, as Lord Griffiths said, When someone was unaware of being detained and suffered no harm as a result, only nominal damages will usually be awarded, and as long as the claimant suffered wrongful interference with that liberty, it should remain actionable when even there's no proof for special damages. In Malaysia, through the more recent case of Timbalan Menteri Keselamatan Dalam Negeri Malaysia and Ong San Hui, at the High Court, the plaintiffs sued the first to fifth defendants for damages for false imprisonment relating to the plaintiff's detention under detention order. At the conclusion of the trial of the action, the learned judge found for the plaintiff and awarded general damages in the global sum of ringgit 300,000 due to extension period of detention by the defendant through the second extended detention order being issued by the second defendant.
Just like all the other types of trespass to persons, false imprisonment also has defences available to the defendant. And the main defences available are necessity, lawful imprisonment, and voluntary. The first defense is necessity, where the defendant apprehends any breach of peace or any disturbance of public tranquility from the plaintiff. He may be kept under preventive detention by the public authorities. Police and other law enforcement agencies quite often invoke this measure for maintenance of public peace. An example would be a police who arrests a person or restraining a section or a crowd of protesters with reasonable belief in order to protect public safety. A case on par to the example given above is shown in the case of Austin and Metropolitan Police Commissioner. In this case, the plaintiff has been present in the demonstration and was prevented to leave the Oxford Circle for 7 hours. They brought a case against the defendants, in this case, the police officers, for false imprisonment. The courts, however, dismissed their claim as they were confined in the area to promote peace, to retain peace rather. The crowd control was a necessary measure to keep the public order and protect the interests of others in the community. Therefore, the defense used by the police was upheld and the claim was dismissed by the courts. Moving on to the second defense available to the defendant, known as lawful imprisonment. If it can be proved without beyond doubt that the burden of which falls on the defendant that the person was confined for a lawful cause, the complaint of false imprisonment shall fail. As seen in the case of Robinson and Balmain and New Ferry Co. Limited, the plaintiff entered the defendant's wharf by paying entry fee in order to go across the river by one of the defendant's boats. Upon returning there, he found that the boat had already left. He wanted to go out the wharf. To go out, according to the rules, he was to pay again, which he refused. The defendant did not permit him to go out until he paid the fee. This was held to be a lawful imprisonment as it was part of the bylaws that one should pay a fee before leaving the wharf. In the Malaysian context, Article 5 of the Federal Constitution provides that where a person is arrested, he shall be informed as soon as may be of the grounds of his arrest and be allowed to consult and be defended by a legal practitioner of his choice. In the case of Abdul Malik bin Husin and Borhan bin Haji Daud, the plaintiff was arrested without a warrant of arrest by a group of special branch officers. He was never told reason for arrest and was physically abused while in detention. Furthermore, to make matters worse, he was detained for 57 days. The courts, with reference to the Article 5 of the Federal Constitution, held that there was false imprisonment as it was unlawful, as he was not communicated of his rights and he wasn't given the chance, the right to a lawyer, and amounted to false imprisonment. Last but not least, the final defense available to the defendant in the context of false imprisonment is voluntary. If the defendant validly consents to what the defendant does, the defendant will not be liable of any tort, and this can be used as a complete defense similarly to the defenses that are stated earlier on. As seen in the case of Hurt and Rudell, Steel Coke and Colco, a miner was partway through a shift. He was asked to do some work he considered dangerous. He refused and asked to be taken back to the surface, but was kept waiting for 20 minutes. He then sued for false imprisonment, but the courts held that the defendant was not liable as he had implied consent to stay underground for the length of the shift. His contract of employment with his employer to work in those dangerous conditions was a form of consent, and the consent to work was a complete defense to the defendant. And therefore, defendants were not liable as they used defense.
To conclude, Darian will be talking about the application of these theories in the model.
Marion Graham White Aviation Company Limited, Birds and Jones, the Crown and Governor of Brock Hill Prison, Letang and Cooper, Fowler and Lanning, Fagan and Metropolitan Police Commissioner, Abdul Malik bin Hussein and Borhan bin Haji Daud, Haystead and C.C. Derbyshire. What do the above cases have in common? They are all related and they represent landmark cases towards the development of tort law, trespass to persons, and the lacunas involved, to be specific. Based on the demonstrations and explanation that my group mates, whom you have just witnessed, we now have a better understanding in regards to an important element of the tort law which reflects on the tort law of element of trespass to persons. What the audience has just been educated and informed on were the three forms of trespass to person: assault, battery, false imprisonment, in which we have defined in an accurate manner as per the development of the law, closely related to past cases as how I've mentioned in above, which how it was established, presidential case laws, and then refined further to the standards we have today. In both Malaysian law and the laws in the United Kingdom, and their distinctions has also been explained and brought up and demonstrated by my group mates. Here's a recap on the key information that has been brought up. The whole reason in which warrants the development of tort law is to protect a person's civil liberties and personal rights. Whereas a person is able to make claims towards another individual or corporation as of when an infringement of their rights and where there is a violation, especially if it's a strict liability tort. And if claims are proven successful by the courts, the claimant is entitled to remedies which could be in monetary nature and at an amount deemed suitable by the courts. In each particular part of trespass person that has been explained, for a particular part to be brought up successfully, there must be elements which are required to be fulfilled. When there are elements of the part has been fulfilled, then and only then, there can be an establishment of the different types of trespass to person. We have also learned that certain types of trespass to persons can be brought up in both civil courts and criminal courts, depending on the severity and interest of the claimant, public interests, but not at the same time. And one factor that determines which court it gets brought up to would be depending on what form of justice is the claimant looking for. Remedy and monetary damages awarded, or justice for a lesson learned against the defendants. Defendants are not all the time defenseless, you know. There are defenses in play whenever a court case or lawsuit is brought up relating to trespass to persons. It just depends whether there is a suitable defense for the defendants. Whereby with these defenses in place, they act as safeguards for when there is a constant consent, necessity, or arguably an act of self-defense for the plaintiff to when a suit is brought up. There's also various types of doctrines which can be related, such as the doctrine of transport malice. Therefore, we sincerely hope that this video presentation would help your party understand the concept and principles behind the trespass of person and elements which makes it effective in today's court of law. Thank you.